This episode of AHLA Speaking of Health Law is sponsored by HMS Valuation Partners. For more information, visit hmsvalue.com.
Welcome to today's AHLA Speaking of Health Law podcast. I'm Rob Holland, Director with HMS Valuation Partners, and I'll be your moderator today. Today's episode is titled Beyond the Paperwork, Practical Insights for Navigating Fair Market Value in Healthcare Transactions. We'll be talking about how attorneys can better navigate the business realities behind healthcare transactions, manage compliance pressures, and work with valuation experts in a practical way. We have three fantastic guests with us today, so let's kick things off with introductions. Would each of you share a bit of your background and highlight the areas of health law you work in? Eric, let's begin with you.
Okay, thanks, Rob. I appreciate it. I started practicing in 1992, specializing in healthcare in 93, starting in private practice, and then most of my career in-house. Was at Penn Medicine in Philadelphia for 18 years or so. That was where I spent most of my time and did most of the sort of larger transactions for the system. And I've been in private practice now under Neff Health Law for the last 4 years in Connecticut.
Very good. Thanks, Eric. Let's go to Ragini. Why don't you go next?
Hi, I'm Ragini Acharya. I am a partner at Husch Blackwell in the Healthcare Regulatory Group. I do a lot of healthcare transactions and the associated regulatory work along with those transactions, and transactions involving not just M&A, but also strategic partnerships, collaborations, affiliations. I've been working in this space for 11 years now. And yeah, I've been at a firm in the big firm life for the last 11 years and learned a lot of really cool lessons, and I'm excited to share some of those today.
Very good, very good. And finally, last but not least, Kyle, why don't you share a little bit about yourself?
Thank you so much. Hi, Kyle Faget. Thanks for having me. I'm a partner in the Boston office at Foley & Lardner, and I sort of straddle the life science and healthcare world, both. So I do quite a bit of research and development, collaboration, clinical trial, and then commercialization and compliance, building and scaling for life science companies. And then I kind of do the same thing on the other side of the house, the provider side of the house. In particular, I'm helping building and scaling telemedicine companies into 50 state offerings. So, friendly PC structure, corporate practice of medicine, all those sort of healthcare specific considerations.
Very good, very good. Well, thank you all for being on the show today, and let's get started. Let's start with the idea of getting your hands dirty, or really engaging in the business dynamics behind a deal. Eric, when you think about how attorneys can maybe add value beyond just drafting documents and passing them back and forth between the parties, what does that look like for you in your practice?
Yeah, so I would say, in my experience, a lot of particularly younger lawyers have a misconception about transactional lawyering that I've often referred to as ivory tower lawyering, by which I mean I will sit here in my ivory tower, and when you have an issue, you come to me, I'll sort of pronounce judgment on it, you take it back to your business, and that's how we'll interact. And I think that level of passivity, it might work in some contexts, maybe in litigation where, it's sort of a pleadings type practice. In transactional lawyering, it's really just bad lawyering. And if you think about it, the main reason is I think one of the great things about transactional lawyering is you're always working on something that's positive for your client. Not always, but you're working on a growth part of the business. Maybe it's an acquisition. Maybe you're just doing a new telecommunications contract and it's about cost savings. But it's usually an opportunity for the client, and their primary thing that they want to accomplish is to get it done. They want to not get in trouble too. So I'm not sort of minimizing fraud, abuse, and other regulatory issues, but they want to get the deal done. And that's really, I think, lawyers need to take that on as their role. When I was a young lawyer, my first in-house position, I had the president of the division that I worked for at NovaCare in King of Prussia, Pennsylvania, took me down to his office. He was really struggling with me. And he said to me, Eric, I don't need a lawyer. I need a business partner with legal skills. And that was really one of the great aha moments in my career. I had not understood that before that moment. And it really has changed my whole approach. And I've sort of bandied about this, this metaphor of the tennis player lawyer who hits the ball over the net and then waits for the other side to hit it back, and the hunter lawyer who chases it down until it's dead. And what I would say is you want to cultivate a reputation for being a hunter, because clients who see that will seek you out. And clients that see that you're passive about doing transactional work and you're just sort of pushing documents, they'll see that too. And that will reflect on the success of your practice.
Very good, very good. Ragini, from your perspective, you're often in the middle of these negotiations, structuring the governance and working on the joint ventures. How do you balance legal precision with helping the clients move the deals forward efficiently?
I think that's a really good question, and I kind of want to echo a lot of what Eric said. Audience can't see this, but I'm wearing my tennis racket necklace actually, and hope nobody will judge me for it as a tennis player. But I think it makes a lot of sense to say that, yeah, you don't want to just be in a situation where you're volleying drops back and forth. And a way to make sure that that doesn't happen, in my experience, is I kind of set a few rules. One is be effective and efficient about communications, and so what that means is know who has what roles and who's supposed to be communicating about what when it comes to a transaction. Make sure those channels are clear. You're not asking questions about, decision making that somebody is not in the role to be answering questions about that. The lawyers can kind of help facilitate those conversations and figuring out who should be answering questions. And I think it's really important for the lawyers to make sure that the business teams know who those people are. And in that same vein, it's really important also to understand who the stakeholders are. And, it's not just always going to be the folks in the C-suite that have an interest in making sure a transaction goes through and what the result is at the end of the day. There's employees, there are clinical staff, the list can really go on. So it's not just your owners or your C-suite folks. And so in understanding who the stakeholders are, that can help you understand where flexibility can be built. And if there's flexibility, that can also create efficiencies. My third rule is to set timelines and milestones. You have to accomplish certain things in the process of a transaction, certain documentation, certain filings, and knowing those up front is really important so that you don't lag behind in making certain decisions while other things are kind of sitting out there. So kind of keeping these three things in mind, I think those have always been helpful in helping to create those types of efficiencies. And while we're always really concerned about making sure every I is dotted and T is crossed, knowing what's important and where to focus your energy, keeping these kind of rules in mind will help move that along.
Very good, very good. And Kyle, from your experience under a corporate integrity agreement, you've seen how maybe being too reactive can create risk. How do you stay proactive in your approach to compliance and deal making?
Yes, that's a good question. I mean, and I think this is what makes, of course, healthcare transactions a bit different than other types of transactions. You're in such a heavily regulated space, and often in diligence, you end up uncovering issues. Like, say you're looking to acquire and you're doing diligence on a target, and you really have to understand what's your client's risk tolerance. And similarly, when you're advising a client that may be preparing to be acquired or to acquire, I think it's really understanding the risk. Like, there's, don't let good be the enemy of perfect kind of thing, that you can really get caught up in the weeds and try to have everything be absolutely perfect. But in the process of doing that, you're going to grind a business to a complete and utter halt. So kind of understanding where there's some gray and being able to communicate that effectively with clients and help them understand, okay, if this decision doesn't pan out or goes south, like what are the consequences? And there could be legal consequences and there could be business consequences, sometimes both. And being able to parse those out for clients, I think is really important.
Very good. And I'll just open this up for any of you guys. Where do you see attorneys adding the most value when you take on a more hands-on role? Where do you, or maybe even where do you see maybe missed opportunities when counsel remains too distant, from the business discussion?
I think there's a lot of value to be given in using prior experiences. I think that sometimes, I think to Eric's point, a lot of maybe younger attorneys view a lot of things in a silo, and it's helpful to maybe think about, anecdotal evidence of where things have gone right, where things have gone wrong in past transactions or collaborations, and kind of be able to use that experience on a going forward basis.
Yeah, I'll just underscore one thing Ragini just said. It's, when you think about building experience, it's not something you do overnight. And I have this mental image of how the internet grew, from the 90s till now, with little tendrils going out and creating connections. And I think that's a good model for what you need to do. Just over time, create a fund of knowledge for yourself and build a web of knowledge so that when issues come up in transactions, you have something to draw from that's relevant. And it's amazing how, in a few years and after doing a number of deals, you'll start to make connections between this deal and the deal you did 3 years ago. And it's very helpful, not only for you in terms of efficiency, but for your client. And occasionally just having an aha, oh, wow, maybe that's a good idea.
Very good. And kind of follow up on that point, a lot of these transactions and everything, it's very complex and there's a lot of high stakes involved in these types of decisions. I imagine oftentimes clients they hesitate or they get stuck in analysis paralysis type mindsets. How do you help guide them towards clarity and taking confident action while staying, firmly within your role as legal counselor?
A lot of times it's helping assess risk, right? Like I think that if you overanalyze, there's risk everywhere, right? And then understanding what is risk that can be minimized, what is risk that you may have to just uncomfortably move forward with if you want a deal to move forward, and helping be a thought partner in that exercise, I think is really important.
I think you'll often be called upon as a thought leader in a lot of transactions. For a lot of clients, especially smaller and mid-sized clients, they're not doing this kind of stuff every day if it's an acquisition or even a lot of contracts. And so they don't necessarily know what all the steps in the process. And so being a leader, without being pushy, but being a leader, maybe a little pushy, and saying this is what we need to do to get from point A to point B can be enormously helpful in getting them through that paralysis that they might feel from just not having done it before.
Very good. Okay, very good. Let's turn to another important skill, that is understanding the client's business. I mean, in healthcare, legal decisions often depend, heavily on operational or financial and regulatory context involved with the transaction. So, Eric, how do you approach maybe learning the operational financial details behind your client's organization?
Yeah, and also not just the organization, but just how the healthcare system works in general. I think, I would sort of sum it up in 2 words. It's really about intellectual curiosity. Taking the time to ask your client questions about how something in the practice works, taking the time to Google something you don't understand in a document or in a regulation, sort of something that you read in a Medicare rule that you didn't quite get. It's so important. And one piece of advice I would give that has served me very, very well, but may be difficult for some people. I'd be interested actually to hear what Ragini has to say about this, is because I work in the environment I work on, it's relatively easy to say to a client, by the way, I'm not going to charge you for the next 5 or 10 minutes, okay? But I want to know X about your business. And I've never had a client that I can think of be sort of irritated by that. They're always delighted that you want to learn. But, I think you need to sort of be explicit that you're off the clock for a little while. Now, I think that might be a bit of a challenge sometimes if you're in a firm and there might be, there's pressures to bill a certain number of hours, and maybe you work for a partner who's not, is open to that. But I have found that some of the best conversations I've ever had and the best learning I've ever had is chatting with a CEO for, 10 minutes about some aspect of their business. And again, it's incremental. Over time, you really build up a big fund of knowledge. But if you're not the kind of person that has that type of that type of curiosity, it's going to be more of a struggle, I think.
I have to agree with that, Eric. And I think that's a really good point. But, your comment about, I'm not going to charge you for the next 5-10 minutes. Think of it as, I think it's really important to think of that time. You're investing in your own career by asking those questions and gaining that knowledge. So that's something an attorney can really, yeah, you're not charging a client, but you're adding value to your own knowledge base and to your own career down the line. So it's really worth it to understand those questions.
I totally agree with that. I think that it makes a ton of sense. And you have to invest in your client. You have to be interested in your client, or they'll move on to another counsel that is, in fact, interested in what it is that they're doing.
Excellent. Excellent. I'd like to just take a second to real quickly touch on the growing presence of artificial intelligence type tools that we have. How do you see technology supporting transactional practice, and where might it fall short compared to, say, the human judgment that's informed by what you've been talking about, the real business understandings? Would anyone like to share maybe your thoughts on what role AI can or maybe should play?
I mean, I can see AI being able to undertake diligence in some ways and be able to at least flag important documents in a much more efficient manner than human beings can do, going through the traditional document review, data room, deep dive. But how to make sense of what the documents mean, that I think is a human exercise as opposed to an AI exercise.
Yeah, absolutely. I completely agree with you, Kyle. And I don't know who said this, so I apologize for not being able to give credit to this quote. But somebody has said that lawyers aren't going to be replaced by AI, but AI is going to. Oh, sorry. Now I'm going to blank on the exact phrase. But it's basically like lawyers who know how to use AI are going to replace those that don't know how. I didn't articulate that as beautifully as I intended, but I think the idea is that it's a tool to be used. And I definitely see it continuing to play a role in transactions going forward. I think to Kyle's point, in the diligence process, being more efficient about basically condensing and summarizing all the information that you need to digest in order to conduct the transaction itself.
I tend to be a little bit more skeptical about how long it's going to take before large language models are going to overtake lawyers in certain areas. But I think in terms of, drafting, because I think a lot of us in transactional worry about the production of documents. I think it's going to be longer than a lot of people think, but I think it's going to be a heck of a lot longer for things that require reasoning. And so, if you want to differentiate yourself, you've got to move past document production and sort of thinking as the deal, as the negotiation of the documents, and start thinking of the deal as a cog in your client's business that the documents are supporting. And I don't see I don't see large language models overtaking lawyers in that type of reasoning, probably within the career span of anybody who's graduating from law school soon.
All right, very good, very good. So let's shift gears just a little bit, and we can talk a little about regulatory complexities and valuation, and where those kind of intersect. I'll start with Kyle. So why do healthcare provider consulting arrangements, why do those attract so much scrutiny from regulators, just kind of as a jumping off point?
Sure. Well, I mean, your garden variety consulting agreement can be used as a mechanism to incentivize prescribing. And so that implicates the anti kickback statute. So it's actually really important that consulting agreements are undertaken for a legitimate bona fide business need, and that the payment that occurs as a result of actual work performed, and that it's in line with fair market value, so that it is not the case that industry is lining the pockets of clinicians to ultimately prescribe their drug or utilize their medical device or app or whatever else might be on the table for use. That's really the biggest piece. So then understanding what it is that is fair market value for work undertaken is really important. And lawyers don't determine what is fair market value. We just let our clients know that you need to figure it out, and that's what you should pay. And that's where valuation firms are critical.
How about also maybe within the clinical trial related compensation arrangements?
Same
Is that
thing.
another area where you find kind of the fair market value
Yep.
being a
Yep.
challenge?
It is because you have to figure out like what's the actual procedure cost. And so if you're an industry sponsor paying or underwriting a clinical trial, you need to figure out like even something as simple as, okay, are you paying like per procedure, per visit, per total patient? Because when a regulator comes in and looks, there's like a whole bunch of different ways you can slice the pie to ensure that any given payment is actually fair market value. So yes, absolutely. Clinical trials are like, a huge budget that can be analyzed from fair market value perspective, upside down and backwards, to be honest.
Very good. For Eric or Ragini, do you see similar challenges in your practice for different kinds of transactions?
I mean, I see that. I think there are certain situations where valuations are critical, and certain situations where valuations can sort of take a little bit more of an informal route. And there's so many variables in that, but a transaction where there's an acquisition of a practice and you need a practice valuation, and the two parties are referral sources to one another is kind of a no-brainer. I guess I would say in response to that one thing people should be sensitive to the fact that when you're recommending a valuation to a client, your recommendation comes with a cost. They're going to have to pay for that valuation, and you need to be sensitive to that. And you need to educate yourself in such a way that you can justify your position on that. And if you think about it, within larger companies in particular, there's a budget process, and the person you're speaking to on the phone is responsible for getting this transaction done within a certain budget. And it's tough sometimes for them to accept the fact that, God, I got to spend, $14,000, $16,000 on a valuation. And suddenly you become the enemy in that situation. Lawyers making me do this, right? And you've got to be sensitive to that. I'm not saying don't recommend valuations when they're appropriate. I'm saying be aware that it's not done in a vacuum, and make sure that you can articulate why it's necessary and why it's going to help them down the line.
I think to jump off of that too, I think it's important to consider and articulate to the clients and providers what the points of negotiation would be when it comes to obtaining a valuation, right? Like it's not just go get a valuation. It's okay, well, are both the parties or all of the parties going to obtain a valuation, or just one of them? Who's paying for it? What are the parameters and assumptions that are going to be associated with that valuation? What information from that valuation is going to be shared amongst the parties? You may have to do a common interest agreement. So those are all things to consider about, when a client's trying to decide whether or not to even obtain an evaluation. it's not just do you get it, yes or no. It's what does it mean when you actually do get it? Who's paying for it, and what's the scope?
Very good. And Kyle, having a practice under the constraints of a corporate integrity agreement,
Yep.
what was that experience like, and what lessons can attorneys draw from that level of external oversight?
Yeah, I mean, what's difficult is that your whole program is going to be audited on an annual basis by an independent review organization. And so you're really living under a microscope. So you don't have as much latitude to uh, assume risk where you otherwise might, because again, you're operating under a microscope. So it can be very taxing. It's very expensive. Sort of think risk benefit analysis. If you undertake a risk on the one hand and maybe don't get that valuation and then find yourself on the wrong end of an accusation of kickback, for example, I promise you're going to end up paying a whole lot more than you ever were going to for the valuation in the first instance.
Very good. Would anyone else want to share some similar type experience where, having been more proactive, or had you been more proactive, it might have helped the client avoid getting into that type of situation in the first place?
Where do I begin? I mean, obviously my experience is going to be different than Kyle's working on, clinical trial agreements, and mine are mostly in the context of transactions, where a formal valuation wasn't obtained at the front end when it probably should have been, or when one was obtained, but it wasn't done under the right parameters. So, I mean, it's helpful to work with, I think, your attorney and like explain the processes that the client is going through, and the decisions and the factors informing those decisions. So, again, I'm going to harp on communication channels to make sure that, the less things that can go awry do. Eric, I don't know if you've had any experience with that.
I would say that I'm trying to think of I can't recall a situation where we went back and said, "Gee, I wish we had, gotten a more formal valuation," and we didn't, or we did something sort of more seat of our pants. I can't think of a situation like that. I can think of situations where the quality of the valuation was not strong, and that questions came up in an investigation where there were some uncomfortable questions that the valuation person that we had hired was not really very effective in answering them, and they weren't really in the report, and that created ultimately the outcome was okay, but it just created consternation with the regulators in this sort of general sense that we had not done things as completely as we could have.
Very good. So, Eric, then what makes a valuation firm, what makes them good to work with? Like, what do you, as attorneys, what do you need from them to feel confident the valuation will hold up?
Yeah, I would say that probably the thing I value most, first of all, I would say that you need to be involved, if you can be, in vetting a valuation firm. In some cases, it's somebody who's well established and it's not an issue. But I've had a number of people who are CPAs, don't have a lot of valuation experience, that may not be properly credentialed, that say they can value a practice, who really don't understand the healthcare industry well enough to do that. I mean, the revenue end of valuation in this industry is about as complex as it gets. It's not like valuing an inventory at a shop or something like that. So being involved in that vetting process, I think, is really important, because you're going to be looking for things that the client might not be looking at. I would say the thing I value most probably is integrity. What I mean by that is I've had a couple of occasions over my career where the person on the other end of the phone, sort of wanting to get the business, said something along the lines of, "I'll make the numbers say what you want them to say." And the rest of the conversation to me is wah, 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 wah. That immediately disqualifies them as far as I'm concerned. I mean, I understand there's some flexibility and some range, but that's off the table as far as I'm concerned. So that's I think part of it. The other thing I would say is you've got to. This goes back to what we were talking about before. You've got to educate yourself about the fundamentals of the valuation process as a lawyer to understand how to make a recommendation and whether to make a recommendation. So, how does a discounted cash flow analysis work? What is EBITDA? What is an appropriate multiple of EBITDA in a case like this? Can you just do a cost, an approximate cost, and then divide it by the number of hours? How do real estate valuations work? Is common space part of it? Is dead space part of the how the calculation works? And I guess in concert with that, I would say develop a relationship with an experienced valuation person and use that person or work with that person as an ally, right? Because if you need to convince a reluctant client about an expensive valuation, having somebody that, next to you saying, yeah, I agree, and this is why, but with the financial end of the experience is critical. And also having somebody to, as a sounding board. I mean, I've developed a lot of rules of thumb over the years, to sort of approximate, do we need evaluation in this case? Are there stark issues where, intent is not relevant, or is this in a situation where we've got two referral sources? But I've kind of developed some rules of thumb, but I generally call somebody and say, here, this is the way I'm thinking about it. What do you think? And if you have somebody that you can call and develop that kind of an alliance with, I mean, and somebody who's willing to sort of play that role, and it's just, I mean, it's indispensable as far as I'm concerned.
Very good. Ragini, you want to share any insights you have on how to work with or choose a good valuation partner?
I think I have to echo everything Eric just said. I don't think I could say it any better than that. But the one thing I would add is, be aware. There are a lot of valuation consultants out there, obviously, and everybody I think has their like their area of expertise. And so it's important when you're picking, a valuation consultant, or as an attorney, you're helping your client vet valuation consultants. You understand what their areas of expertise could be and how they can help, identify value drivers and things that somebody else might overlook. So that would be the only thing I would add to that.
Very good. And Kyle, would you like to add anything on that?
I mean, I just want to echo what Eric said about disqualifying anybody that says we'll make the numbers work for you, because that's going to end up being indefensible. And so you just, you might as well light money on fire.
By the way, I'll add to that a little bit too. And Kyle, feel free to call me on this because you have more experience with this than I do. But when you're vetting someone, think of them as, you're sitting at a table with a regulator explaining what the theory of this deal was. And who do you want sitting next to you? You want somebody who's articulate, knowledgeable, and comfortable in a high stress situation where it matters what they say, and they're not bumbling around to looking at numbers and all of that kind of stuff. So part of the vetting process is, how is this person going to play at the table with a regulator if we ever have the misfortune of getting to that point?
Great.
Very good. Very good. Well, y'all have shared some excellent insights into, the challenges, complexities of FMV and compliance. For our final segment, I'd like to turn to maybe more the practical side. Let's talk a little about the skills, maybe habits that can make attorneys better advisors in these types of transactions. So let's start with Ragini. For attorneys working on their first governance project or joint venture, what practical advice would you offer, maybe particularly around setting expectations, or, like you mentioned before, managing different stakeholder interests?
Yeah.
Just to avoid those, those pitfalls.
Yeah, absolutely. I mean, I'm just going to reiterate it again. I think knowing who the stakeholders are, you have owners and you have your C-suite, but knowing who is really making the enterprise work and who's making the venture work. And it's not obviously just that group of people, it's also your employees, your clinical staff. So I think it's really important to consider all of those stakeholders' interests and where those interests may fall in the drafting of agreements and structuring of governance. So by way of example, if you think about an ASC, right, you don't just have your board of managers, you also have your medical director, your administrator, your medical executive committee. And so and knowing that as you're drafting all the documents, that kind of those foundational documents that address the responsibilities and roles that everybody's playing, you need to know who's playing those roles. So really think about it from a big picture perspective. I don't we get taught a lot of A, B, and C in law school, like you have a purchase agreement or you have an operating agreement, but there's a lot more to it than that. And I think sometimes some of those ancillary documents and thinking about these additional folks kind of falls by the wayside, and it shouldn't. It really shouldn't. I think a couple other things I would mention, which we've kind of talked about already today, but managing buyer seller, your client's expectations when it comes to timing and what it's going to take to complete a project, from a regulatory perspective. If you're doing a transaction and it's going to require some sort of state agency transaction approval, setting those expectations from the start, it could set you out 5, 6, 10 months, a year, and making sure that the parties are aware of what that means operationally. And then finally, this is my personal one. It's knowing which hills to die on, and when it's not necessary to be a jerk. I think Eric would agree with me on that, but knowing exactly when it's worth fighting over a small point or language in a form. Sometimes we kind of want to stick our feet and dig our heels in and say that, oh, it's my way, my draft is the best draft, my articulation of this is better than yours. And really, at the end of the day, your goal is to get your clients to a place of agreement and get your clients to an end goal, this partnership, this collaboration. And being a jerk isn't going to get you there. So that's my last tidbit.
Very good. And Kyle, for when attorneys are working with compliance teams or valuation experts, what practices or approaches do you follow that might lead to smoother, more effective relationships, and what missteps, should they avoid?
Yeah, I think taking time to listen to all the various viewpoints and consider them before figuring out and deciding what hill you're going to die on. I think that's a really important exercise.
Very good. And Eric, from your perspective, like what does it look like for an attorney to evolve into that trusted advisor role rather than just someone who is more reactive to issues? And what practical steps, might help attorneys make that transition?
I was thinking about this earlier before we got on this podcast, and there's a story I like to tell about Richard Feynman, who was a physicist who won the Nobel Prize for Physics years ago. And he talks in some papers about his relationship with his father when he was a child. His father was not a scientist, but they used to look at ants and insects together. And Feynman said, the best gift that you can instill in your children is the gift of intellectual curiosity. And I think that's good at career advice also, because asking questions and not being afraid of ignorance, of your own ignorance, is such a great way to advance your knowledge and your career. Ragini made reference to this earlier, that or sort of early in your career, you might be inclined to sort of there are just going to be things you don't know, and saying I don't know what that is, and taking the risk of sort of looking ignorant about something is a great way to learn. And the more pieces you put into the puzzle, the better you'll get at it, and the more valuable you will be to clients, and the more calls you'll get, to be frank.
Agree.
Very good. Well said. Well said. So I guess if there's one final piece of advice, and anyone would like to share one final thought that maybe we touched on briefly you want to expound upon, now's your chance. We can try to share with the audience today just something to help, like looking ahead and going forward. What's one last piece of advice you might offer? Kyle, how about you go first?
Ask questions. I think that was really great. Just, what Eric said, I parrot that 100%. Ask questions. It's okay if you don't know something. It's actually not okay to pretend that you do when you don't.
Very good.
I would say doing deals is fun. It's one of the most fun parts about being a lawyer. I've been other stuff that's not quite as fun. Have fun. If you have fun, you'll get good at it. Promise.
Very good.
I will echo that and say, again, don't get stuck on trying to always be the winner. Always remember that what the end goal is, and that, being a nice person will sometimes get you further towards that goal than just sticking your heels in the sand about stuff.
Very good. Well, thank you all for this thoughtful and really practical conversation. Your insights into deal dynamics and fair market value challenges and just general business-minded lawyering are incredibly valuable. And to our AHLA listeners, thanks for being with us. We hope you found this discussion relevant and useful, and take care, everybody.